If you're concerned about banded hours contracts or how to calculate what band an employee should be put in for the purposes of a banded hours contract, then this video should be of assistance to you. My name is Terry Gorry, I'm a solicitor, and in this video I'm going to look at a Labour Court decision there recently which dealt with the calculation of a banded hours contract entitlement and which band the employee should have been placed in. And it's an important decision because it deals with the question of annual leave. Let me explain. There was an employee working in Aer Lingus. She brought a claim to the WRC for a banded hours contract. The WRC adjudicator agreed with her that she should have a banded hours contract, that she was entitled to it. And this is pursuant to Section 16 of the Employment Miscellaneous Provisions Act 2018, which basically inserted a new Section 18A into the Organisation of Working Time Act 1997, and it makes provision for banded hours contracts, an entitlement to arise for employees based on the average number of hours they do on a weekly basis. In this particular case, the case was against Aer Lingus, and Aer Lingus agreed that the employee was entitled to a banded hours contract and was perfectly happy to give her one. However, the band that they placed her in was a band F, which was an average of a working week 26 to 31 hours. But in arriving at the figure for the average annual or the average weekly hours, the Aer Lingus, the employer, took into account the employee's 4 weeks of annual leave. Therefore, the employer took all of the hours that she worked and divided her hours by 52, and that gave a particular average. However, the employee argued that the annual leave should not be taken into account, and if that in this calculation, and if that was the case, then the total number of hours worked in a week by the employee would be divided not by 52 but by 48, and 48 as a divisor would give an average working week greater than what she had been given, and would put her from band F, which is an average of 26 to 31 hours per week, to band G, which is an average of 31 to 36 hours per week. So big difference for the employee. There was a dispute then. The adjudicator agreed with the employer and gave her the lower band. However, the decision, I think, was appealed to the Labour Court. It was appealed to the Labour Court. I'm not sure whether it was the employer or the employee who appealed it. In any event, it ended up at the Labour Court, and the Labour Court had to decide on the question of whether the employer's argument was right, that annual leave and the amount of annual leave should have been calculated, taken into account in the calculation, because the argument obviously is that annual leave is considered to be working time under the Organisation of Working Time Act 1997. The employee argued that no, that should not be taken into account, and therefore she should have been put in a higher band. The Labour Court basically looked at the legislation, decided that there was ambiguity there, decided that unfortunately working time was not actually defined in the particular act that gave the banded hours contracts, entitlement and so forth. But the Labour Court did look at the intention of the Oireachtas in putting that entitlement on the statute books, in looking at in putting the particular Miscellaneous Provisions Act 2018, Employment Miscellaneous Provisions Act, on the statute books, and decided that it would be a mathematical certainty that if the annual leave time was taken into account in the calculation, then the actual hours worked by the employee would not be reflected in the calculation. In other words, if annual leave was included, it would have the effect of lowering the average weekly hours worked by the employee below what they would normally work. For that reason, the Labour Court decided, and it's an important decision, that for the purpose of calculating the banded hours contract entitlement, annual leave should not be taken into account. Therefore, if an employee has, for example, 4 weeks holidays, then the reference period for the purpose of calculating the banded hours contract is 48 weeks. That is 52 less 4, 48 weeks. And that's going to give the correct banded hours contract and the correct weekly average number of hours worked. If you find anything useful in this video, I would appreciate if you gave it the thumbs up down below, and thanks for watching.